Ni awali ni kwamba bunge la Seneti leo linafanya kikao maalum kuisikiliza kesi ya kutimuliwa madarakani gavana wa Kiambu Ferdinand Waititu, katika kikao ambacho kitahudhuriwa na wawakilishi wadi katika kaunti hiyo. Tuvuke moja kwa moja katika kikao hiki cha jopo la maseneti 11 ambao wanasikiliza kesi hii, tujue iwapo Waititu ataponea ama namna gani. Tuvuke kule.
You not only budget, but you do not procure anything that is outside of that budget. You will see that that stipulation will have been violated. When it comes to the question of the breach of international or national law, this is where you will find some fairly shocking evidence. And it is shocking at 3 levels. Governor Waititu used his office, the office of the county government has a mandate of fiscal planning under the Constitution. You will find evidence that a widow who was left property by her husband, her deceased husband, applied for planning approvals. When she applied for that planning approvals, the county government involved itself in machinations to try and frustrate that process, including trying to compulsorily acquire that land. The widow had to go to court to compel the county to undertake its mandate. Now, that's not the shocking part. The shocking part is that the widow received a telephone call that called her to the governor's office, and the governor personally demanded from her that she transfer 2 parcels of land, and those parcels of land were to be transferred to his wife so that she could get the approvals that she needed. Because of her desperate situation, she did that. But fortunately, the Constitution provides a remedy for her. And she went to the Commission for Administration of Justice, the Ombudsman, and made a formal complaint. The Constitution and the Act that sets up the CAJ provides a mechanism that allows one to complain and empowers the CAJ to inter alia investigate abuse of office. So she went to the right forum. The CAJ carried out detailed investigations, called Mr. Waititu, called his wife, and they confirmed that the property had been transferred to the wife for no consideration. The CAJ made a finding in a ruling that implicated Ferdinand Waititu personally for that particular offense and ordered that the property be transferred, and that was done. So when you are retired to deliberate, I think this is one of those offenses for which really, apart from breaching the Constitution, Article 40, the right to property, apart from breaching the law in terms of abuse of office, this conduct is contrary to the Bible. Exodus 22 tells us, do not oppress a widow. And if you do, the wrath of God shall be upon you. But I do not wish that the senators look at Exodus. Governor Waititu will meet his maker on his judgment day, and he will be able to deal with that. But you will find that the evidence shows that this is a man who not only breaches the Constitution and the law, but one who is not even afraid of the wrath of God. The last category of evidence that we shall be submitting to you relates to conflict of interest. And the conflict of interest charges are linked to the first group of charges. In the first group of charges, we told you there was a systematic weakening and destruction of the safeguards for the safeguarding of public funds. And there was a reason why Governor Waititu did this. And the reason is that, having weakened the systems, Governor Waititu then proceeded to put at the disposal of his family the resources of the people of Kiambu. Procurement contracts were done that resulted in Governor Waititu's wife and daughters all receiving funds from the county assembly of, from the county budget. This is a clear conflict of interest. The evidence you will see has the tenders, the award letters, the CR12s from the county, from the lands office, demonstrating that these properties and monies were going to, contracts were going to Waititu's wives. The only thing that one could say one may commend Governor Waititu for is that he doesn't discriminate. When it came to looting public resources and giving them to the wives, he gave each wife resources. So it is going to be the county assembly's case that the governor systematically weakened the controls so as to put the resources of the county into his family's hands. The last evidence that we will submit is with regard to illegal employment. The employment of county officers is governed by the law, and the responsibility of recruitment is with the Public Service Board. Governor Waititu systematically disregarded that law and employed over 600 people directly. And the letters of appointment are there. You will see them. They are signed by himself directly, in total disregard of the law. At some point, when there were investigations about disappointments by the Ethics and Anti-Corruption Commission, the governor decided to sack these people. So you have double jeopardies for the people of Kiambu. On the one hand, people are employed irregularly. But on the second hand, they are now saddled with potential claims by persons who have been irregularly terminated. It will be our submission at the end that there is compelling evidence and facts, none of which have been controverted by the governor, to substantiate the allegations. And for those reasons, we will be then asking that this Senate do undertake its mandate of protecting devolution. Protection of devolution includes protecting it from persons who choose to violate the purpose for which devolution was instituted. The reason this country passed the 2010 Constitution, partly, was that we wanted resources to go to the people closer. The devolution provisions were not intended to devolve corruption to the grassroots, which is what Governor Waititu and his conduct, as revealed by the evidence and facts, which he has not controverted, will do. So that's the opening statement on behalf of the County Assembly. And this afternoon, we will lead the House through the evidence. Thank you.
Okay, thank you for your opening statements. I now invite Governor Waititu's counsel to give his opening statements. 30 minutes.
Mr. Speaker, sir, I want to have some few minutes as for my opening statement. Then I donate some of my minutes to my lawyer. Mr. Speaker, sir, I will start by thanking the Senate for giving me this chance and opportunity to be heard, a chance that I was denied at the County Assembly. It is important to mention that I had sent my lawyers because I feared the humiliation and the shouting match that could have been in the assembly. I sent my two lawyers, and they were there representing me, but they were never given a chance to give my answers to all these questions that have been leveled against me. I also want to mention that all the answers are lying at the office of the Sergeant at Arms, and the answers are there, and I wish the Speaker will allow that those answers come to the honorable members. Mr. Speaker, sir, I listened carefully to all the accusations, and I also listened and watched the deliberations of the Senate last week, and I must say that I'm happy to know that all the governors who have gone through the Senate, that alone has also had an impact in their counties, positive impact, and I hope that after this process, there will be a serious positive impact in the whole of Kiambu County. Mr. Speaker, sir, Kiambu County, since I was elected, the politics did not stop when I went to the office. There has been a lot of propaganda through social media, bloggers being paid by politicians to malign my name, and it has gone to a level that they always get away with the propaganda and achieve their goals. They repeat a lie so many times, and it ends up looking like it is the truth. Some of you know very well that some times ago, there was an article that went viral that my daughter was found with an account of 100 million. It was found to be untrue. She had an account with only 9,000 shillings. That is the level of propaganda that is in Kiambu County. What I want to tell you, Mr. Speaker, is that now that the matter has come to this House, and I strongly believe that this House has the mandate to give the residents of Kiambu and the whole country the truth that they require, the justice that they require, and the justice also should also extend to me as the accused person. Mr. Speaker, sir, when I was given the notice of the motion, the Assembly took over 14 days, in fact 17 days, to deliberate on a special motion. They went against the Kiambu standing orders, as a County Assembly standing orders, which requires that a special motion be disposed of within 14 days. Mr. Speaker, sir, when it came to that day in the Assembly, I was never given a chance to be heard. And I personally had sent my lawyers who are there sitting, and they were recognized from the morning, and they were waiting to be heard after the accusations, and they were never given that chance, Mr. Speaker. That same day, because of that culture of believing in propagating lies, and knowing that they have been succeeding in propaganda, a House that had 57 members only since the whole day of deliberation. Mr. Speaker, the threshold in Kiambu County, as stipulated in the standing orders, the county government standing orders, is 2/3. In Kiambu County, we have 92 members. The 2/3 are supposed to be 62 members for the motion. Mr. Speaker, sir, that threshold was not there in the Assembly. There were only 57 members, and one of the members there voted no. Who voted no in my support, and he was there throughout the day, and he's here. He can testify to that. And Mr. Speaker, sir, the motion that has been brought before the Senate, having not met the required threshold, honestly speaking, having been a member of Parliament twice, having also been a member of the County Assembly of Kiambu and the former Deputy Governor of Nairobi, honestly speaking, numbers count. It is the Constitution, it is the guideline that this and this must be done this way. There are clear procedures and directions, honestly speaking. However bad I might look politically or otherwise, or whatever people should think, but honestly speaking, I should be given justice. I'm just pleading to this house that as a Kenyan, I should be given justice like anybody else, and that is why, honestly speaking, the Constitution guarantees everybody fair hearing and fair judgment. Mr. Speaker, sir, when the motion, which according to me did not meet the threshold, was brought to the Senate, they did also not meet the days that are required. They are supposed to bring the motion after 2 days. They brought that motion to the Senate after 4 days. Mr. Speaker, sir, that is a breach of the procedures and the standing orders of the Senate and of the County Assembly. Mr. Speaker, sir, I would also like to mention that the Senate standing orders also mentions clearly that 7 days are required to summon the Senate. Mr. Speaker, sincerely speaking, members were called well above the 7 days. Mr. Speaker, I'm just requesting you, because I know some of you in 2022 will be governors, like it happened last time. Some senators became governors. Even in this house, I know a big number of you will also become governors. You will also come here and you require justice to be done to you. It will require you come here. I was in this compound for 2 terms as an MP, and I have now come back here in the dock. I'm sure some of you will also come here. And you will require justice to be done to you. I just beseech you to do justice to me as a Senate. Mr. Speaker, sir, all accusations have been said. I have experts in the county who deal with finance, highly qualified staff. And Mr. Speaker, sir, some of those accusations, as you have heard them, they were handled by different people in the county who are qualified to do that work. In the finance, procurement, I'm not part of the procurement process. And I want to tell you as a house that there are so many things that happen in a county that has over 8,000 employees. And I cannot be held accountable by any means of everything that happens to people who are employed there. Yes, I'm the governor, but honestly speaking, there are those committees that I chair, but where I have no mistake, I beseech you not just to be fair. Mr. Speaker, it has been said about the lady and the plots at Thika. Mr. Speaker, sir, I want my accusers here to produce a single document, a single evidence that implicates me. The persons are adults that dealt with that matter, and I have so many relatives who do deal with so many things. Some, because I'm the governor, obviously want to enjoy that title of the governor. But they should be held accountable of what they do. I should be held accountable of what I do personally as the governor. I never myself called the lady, as indicated here. If there is any proof, let the accusers produce. I never at all requested the registrar to transfer the plots. If there is any proof, please produce the proof. I was never called by ombudsman myself. All these issues have come when I was taken to court over the corruption case. and I'm still pushing with my case, and there are so many people who are in court with the cases. I'm just one of them, and I'm still innocent until proven guilty. Honestly speaking, you cannot nail me because of a case that is going on and I have not been found guilty. I'm just requesting, please, the case in court, let it continue. I might be proven innocent, who knows? And honestly speaking, if you pin me because of that case, you will not have done justice to me. So what I'm requesting you, honestly speaking, is that you do all the fairness that is supposed to be done to a human being. Listen to the facts and evidence, but not propaganda. Kiambu is known for serious propagandists. That is Kiambu, that is the nature of Kiambu. And it is my sincere hope. It is my sincere hope. You have seen, even you know the politics in Kiambu right now. And I want you not to judge me because of those politics. Please, make sure, Mr. Speaker, that after all these deliberations, you will change the narrative of Kiambu people, the thinking that they can propagate lies and succeed, that they can hold somebody if they can succeed in getting rid of somebody just because you don't want that person. I'm a victim of that, but I want to request this House that just do justice to me, just be fair to me, just look at the facts and evidence as adduced. I have all the answers of the accusations in the Sergeant at Arms office. Thank you so much, and God bless you. Thank you. I now call upon my lawyer to just for 2 minutes to sum up what we had said. My 30 minutes, I think.
Do we have time?
Mr. Speaker.
Oh, you have 18 minutes. Huh?
18 minutes, thank you very much. I'll actually take less and yield a few more minutes to my learned colleague, Mr. Jenga. Now, Honorable Mr. Speaker, Honorable Senators, today we gather before this august House to discharge a most noble and solemn task that only this Senate can undertake. Mr. Speaker, and this is the consideration of the proposed removal from office by way of impeachment of a popularly elected governor of the second most populous county in this country. Mr. Speaker, this task underlies the supremacy of this House. No other House in this country has the sovereign power to terminate the social contract between a governor and his people, or even the president and his people. Being such a solemn duty, Mr. Speaker, it calls for a lot of restraint and great circumspection. The tool of impeachment, correctly understood, should only be deployed as a measure of last resort, and where it has been shown that all other oversight mechanisms have either failed or otherwise inadequate. It is a duty, Mr. Speaker, that this House has been called into action to undertake. Before it undertakes that duty, Mr. Speaker, this Senate has an obligation to audit the entire process that was undertaken by the Assembly and satisfy itself that that process was proper, lawful, and valid. This is particularly important, Mr. Speaker, because this Senate was not conceived to rubber stamp decisions and resolutions passed by the Assembly. Far from it. Primarily, the Senate was conceived to protect counties and its governments. So one of those protections is to protect elected governors who are the CEOs of those counties. It is important, Mr. Speaker, that this Senate protects governors from marauding assemblies who might seek to deploy impeachment tool for their own selfish motives. We're saying this, Mr. Speaker, because this House is comprised of noblemen and women of great character and integrity, and whom we believe that at an appropriate time they will rise to the occasion and make a determination on the facts, the evidence, and the law, and find that the charges that have been presented or that will be presented before the Senate lacks any basis. There are some critical preliminary issues, Mr. Speaker, that my learned friend will advert to in his opening remarks, and I do not wish to rehash those because Mr. Jenga will deal with those. And this has to do with whether the governor was given opportunity to be heard before the Assembly, whether the constitutional and statutory timelines before the Assembly were complied with, whether there was public participation, and whether indeed some of the charges contravenes the sub judice standing order of this Honorable Senate. Just very briefly, Mr. Speaker, on the facts. You've been told that we have not controverted the facts and the evidence. First, it is the governor's case that he was not given a chance to be heard by the Assembly. So the opportunity to controvert that evidence at that preliminary level was deprived. So it cannot then lie in the mouth of the Assembly to say that the governor has not controverted the charges, the facts, and the evidence. Mr. Speaker, as relates the documents that we have filed, yes, we did file a notice of preliminary objection when we were served with the invitation to appear, but it was not possible, Mr. Speaker, within the 3 days that we had been allowed to present substantive evidence. We shall, as soon as we finish making the opening remarks, make an appropriate application under the relevant provisions of the standing orders for admission of that evidence out of time. I will revisit that shortly. Now, Mr. Speaker, you will be told that there was alleged violation of the Constitution, PFMA, and the Public Procurement Assets and Disposal Act, that there were unsustainable debts that were incurred. What I do not know, what we don't understand is which law provides or criminalizes what is called unsustainable debts. You've been told that the governor has been undermining the Assembly business by not remitting funds to the Assembly. That allegation is not founded on the evidence that we shall be producing. You have been, or rather you've been told that there was failure to adhere to budgetary estimates in procurement and alleged failure to establish the County Budget and Economic Forum. Those allegations are baseless. Subject to admission of the evidence that we shall be producing, we shall demonstrate that that is not factual. Mr. Speaker, as regards allegations to do with conflict of interest, it is important, Mr. Speaker, to point out that that particular charge is the subject of active criminal litigation. Mr. Speaker, we shall be raising an objection in as far as that particular charge is concerned as to its admissibility or consideration by this Senate when it is indeed subject matter of a court process. Mr. Speaker, there are no impeachable grounds that we call crimes under national law. The impeachable ground should be reasons to believe. So we shall be raising again an issue as to how that particular charge is crafted and whether indeed it can found a basis of an impeachable offense under Article 181 of the Constitution. Mr. Speaker, regarding the issue of staffing, again, and procurement, we shall be demonstrating to you that there is absolutely no direct nexus between the alleged violations and the conduct of the governor. The governor plays no role in the procurement process. Yes, he might be the CEO of the county. He does not award tenders. He does not evaluate tenders. He does not sign contracts. So what you will not be told is where the evidence with regard to those subject tenders is and where the governor's hand is. You will not be told all that. You'll be told about alleged high wage bill as a ground for impeachment. This is a national issue, Mr. Speaker. It cuts across all counties, and the reasons are diverse. Delayed release from exchequer, inherited debts from the previous regime. Now, all those have been lumped together
to couch an alleged charge of alleged unsustainable wage bill that has been flowerly crafted to say that the county of Kiambu is threatened with auction. Far from it, Mr. Speaker. We will be demonstrating that that phenomenon has nothing to do with the conduct of the speaker, of the governor. On the whole, we shall be urging this Senate to reject all the grounds, all the charges for not having been proved, Mr. Speaker. I will yield the remainder of my time to Mr. Jenga to make some brief opening remarks on the process issues and the legal deficiencies of the motion that was presented to the Speaker of the Senate by the Speaker of the Assembly. I yield the floor. Thank you, Mr. Speaker.
Thank you, Mr. Speaker. I only have 10 minutes, so allow me to dive right into it. Mine is to speak to a few legal issues that are very material to this gathering or to this session. The court has said, in the case cited by my senior, who interestingly was my pupil master and my trainer, Mr. Nani Mungai, that the jurisdiction of the Senate, the mandate of the Senate to hear an impeachment, flows from a resolution of the County Assembly. So without a resolution, this gathering is not properly constituted. This session to hear the charges against the governor cannot be legally and competently moved without a proper resolution of the County Assembly. And why do I say this? Because in the proper and exhaustive evaluation of the facts, you will realize that there is a fraud upon the Senate. The law is clear to the extent that it provides for a number threshold required to pass a resolution for the removal of a governor. The law says 2/3. When you have 2/3, then you have a valid resolution. The evidence available, and that will be demonstrated, shows that on the material date, only 57 members of the County Assembly of Kiambu were available and participated. That by itself, even without further interrogation, calls into the question of the validity of the resolution and invites the Senate to make a determination as to whether it has been properly moved to hear and determine these proceedings or these charges. The law has said, and the courts have said, that there cannot be justice without the law. I know we are all itching to proceed to the facts. We are all itching to remove the governor. The country is in the mood, people in the mood, but the law is there to safeguard all of us. We are here before a legislature. We are here before the Senate of the Republic of Kenya, which is enjoined under Article 94 to protect the Constitution and the democratic governance of the Republic. So the law is an issue, and we have to consider it as a preliminary issue. The second thing that calls into the investigation of this Senate is the question of statutory timelines. Where the law provides a statutory timeline within which an action should be done and resolved, then there cannot be any other argument. If we are to be loyal, to pledge allegiance, or to be subservient to the law, then we must interrogate our own processes and confirm at the first instance whether we are compliant with the law. The governor is here on allegations of violations of law and the Constitution. Before we put him to the sword, we have to look within ourselves and confirm whether we are properly constituted. And I say that based on the material evidence before this House that shows that this House was notified on the 23rd of December, right before Christmas. The law requires, in no uncertain terms, that the Senate be convened within 7 days. That is Section 33. It does not give any conditions. It does not give any accommodation or latitude to extend that time. The facts herein show Senate was convened on the 21st of January.
Senator Baringo, take your seat. Okay, proceed, Council.
Thank you, Mr. Speaker, for that protection. Senate was convened by the Speaker on the 21st of January, 28 days later. The law says 7 days. Shall within 7 days convene the Senate to hear charges. We were convened 28 days later. So clearly, we cannot ignore the critical issues of law that call to account and to issue the validity of the proceedings that we are now in. And we shall raise them in material detail when we are prosecuting our preliminary objection, but it's important to say that that is an issue that we shall be raising as a preliminary issue. But that being, as I sit, you have been told that there are many allegations against the governor. Yes, they are. And you can see them in the grounds set out. This House has had occasion to hear over 8 such impeachment motions and proceedings. And this Senate has said in reports in matters that I've personally participated in that it is not enough to allege. So what, honorable senators, you must look for is evidence. When you're told a title was transferred, you must ask for that transfer and find out who signed it. If you're told that persons were employed, you must interrogate the process. When you're told that the governor accumulated debts, you must find out whether those debts occurred or were incurred during his tenure, or the inherited debts, what the Auditor General has said about those debts, because all those are factors that have not been disclosed to you. And when you look at them in the very end, you'll be surprised that these are mere allegations. They are high in hype and emotion, but deficient on the evidence. The question and the game here is evidence. That is what you must look for, and in the totality of the facts before you, and I've looked at the documents filed by the County Assembly, there is no evidence filed to support the allegations. And so we shall be saying in our final submissions that the charges before this House have not been substantiated. We shall be making extensive reference to previous reports of this House, because this is a House of precedent. And there are certain things it has said, these are not impeachment questions. Questions like convening a county budget forum, the House has said those are not impeachment questions. They have to rise to a level and to the stature of gross violations as anticipated by Article 181 and Section 33. And therefore, our submission in open in support of the governor's case is that before you, what you have are politically instigated allegations that are deficient in evidence and cannot be substantiated. I thank you, Mr. Speaker.
Okay, thank you very much, Council, for both sides, and the County Assembly of Kiambu and the Governor of Kiambu. Honorable Senators, you have heard from the opening statements weighty matters raised on both sides, and therefore, as per our program, the House will adjourn for lunch and reconvene at 2 p.m. Is it 2 or 2:30?